Hello, Business Laws 2 students. This is episode 6 of contract formation. So we're going to cover a couple of topics in this final, at least the contract formation. After contract formation, we are going to cover title and risk of loss, and that will be the final chapter that we will cover. But we have a few points, 3 or 4 points that we need to deal with specifically on contract formation. Prior dealings between merchants, consideration generally, statute of frauds, other special rules between merchants, and the parole evidence rule. All right, we'll try to get through all of that in relatively short order. All right, so WPS Incorporated submitted a proposal to manufacture equipment for X Pro Americas LLC and Surface Production System. So one company basically agrees to produce goods for two other companies. X Pro and SPS then submitted two purchase orders. WPS accepted the first purchase order in part and the second order conditionally. Among other things, WPS's acceptance required that X Pro and SPS give their full release to proceed and agree to pay all valid costs associated with any order cancellation. The parties' negotiations continued, and X Pro and SPS eventually submitted a third purchase order. Although the third purchase order did not comply with all of WPS's requirements, it did give WPS full permission to to proceed, and agreed that X Pro and XPS would pay all cancellation costs. With X Pro and XPS's knowledge, WPS then began working on the order. X Pro and SPS later canceled the order and refused to pay, of course, the cancellation costs. Where else would the fight be, since that was highlighted in the facts, right? When the dispute ended up in court, X Pro and SPS, the defendants, claimed that the parties' contract was not enforceable because the additional terms in WPS's acceptance had materially altered the contract. The court found in favor of the plaintiff. You know why? I know that I went through those facts pretty quickly, right? They're saying that WPS had basically materially altered the contract, right? The court, there are three bases which we talked about in the last class, upon which we can say that additional terms between merchants may not be accepted, right? Because we know that as a general rule, right, if the parties are both merchants, right, then it's basically the additional terms will become a part of the contract if they're not objected to, unless one of three things occurs, all right? The original offer expressly limited acceptance to its terms. That's not the case here. The new or changed terms materially alter the contract. That's the piece that's at issue here. Or the offeror objects to the new or changed terms within a reasonable period of time, which is not at issue here because they did not, right? They simply canceled the contract. That's not objecting to its terms. They placed the order and then and then instead of objecting, they canceled the order, all right? So why would they find in favor of WPS? Was this not an additional term, right? The court found that X Pro and SPS had given a release to proceed that authorized WPS to go forward with manufacturing the equipment. Remember the release to proceed? He said, we're not going to proceed until you give us, even though we have a contract, we proceed once you give us the go-ahead, right? Because the parties operated as if they had additional time to resolve the outstanding differences. The court reasoned that X Pro and SPS were contractually obligated to pay the cancellation costs. So that's an illustration of the principle that we discussed in the last segment, the rule when both parties are merchants for the purposes of the UCC. All right, so Philip offers to sell 650 pounds of turkey thighs at a specified price and with specified delivery terms. Hundert responds, I accept your offer for 650 pounds of turkey thighs on the condition that you give me 90 days to pay for them. What is the status of Hundert's response? Is that a conditional acceptance, right, that does not mirror the terms under the mirror image rule, right? So this is a sale of goods, right? 650 pounds of turkey thighs. Oh, that sounds like a commercial transaction. Maybe one of them is a merchant of turkey thighs. I accept your offer for 650 pounds of turkey thighs on the condition that you give me 90 days to pay for them. Hundred's response, right, is a counter offer for this purpose, which the offeror, Phillips, may either accept or reject. All right. That is, if acceptance is specifically conditioned, right, on the acceptance of terms, of new terms, for example, 90 days to pay for them, then that is a counteroffer. Same as in the, especially if the parties are non-merchants, right? Because in the battle of the forms and with the flying purchase orders, we know that if both parties are merchants, then additional terms become included. But here, it would not necessarily be happen. So the UCC under 2207 provides another option that can occur when there are conflicting terms in a writing that produces a contract. Sub 2207, sub 3 of, or 2A 2207, sub 3, as the case may be, states the conduct of both parties that recognizes the existence of a contract is sufficient to establish a contract for the sale of goods, whether or not a contract would have been traditionally recognized to have been formed, right? And the terms of the particular contract will consist of those terms on which the writing of the parties actually agree, right? Together with any supplemental terms incorporated under any other provisions of the Act, right? And again, although courts don't like to do this, any gaps that they may then choose to fill in, right? But that will be based on the behavior of the parties, right? If there's a dispute over the contract terms, right, the court can simply strike those terms over which the parties don't agree. So, SMT Marketing orders goods over the phone from Briggs Sales, right? SMT accepts and pays for the goods. The parties' writings do not establish a contract, right? But there is no question that a contract exists. They placed a phone order, right? And there is no written reflection of this, but they behaved as if a contract exists, and orally that's sufficient to actually form a contract. If a dispute arises over the terms, such as the extent of, for example, any warranties, right, UCC 2-207 sub 3 that we just spoke about will actually provide the governing rule. And so if I propose that there is a warranty that should attach to my turkey wings, and he said, oh, that didn't warrant those turkey wings. I mean, obviously there may be a warranty, that attaches to the goods just for their fitness for use, so on and so forth. It's just under basic contract law. But any sort of additional warranties, those could be, even if not disclaimed, right? If they're alleged, they may be stricken, and if the parties don't agree. Now let's make a couple of points about consideration. We've gone through the author, we've gone through the acceptance, and that's taken a bit of time. Consideration, only a couple of points that I think that are really worth mentioning. The Uniform Commercial Code does away with the requirement that there be additional consideration in order to have a contract modification. So you may remember terms like accord and satisfaction or novation, right? Or rescission and formation of a new contract. These were all concepts that were intended to get around the fact that a contract once formed is it's already a complete entity, right? If I wanted to reduce the price of what we already agreed to, for example, that would not be supported by consideration because the contract was already supported by consideration. So what is this based upon, right? The Uniform Commercial Code does away with all of the formalities that one needs to kind of get into with regard to the sale or lease of goods specifically. Next point, you may be recalling the statute of frauds. Well, the Uniform Commercial Code contains its own statute of frauds provisions, right? For example, under these provisions, if it's the sale of goods for $500 or more, those goods, the sale of those goods must be in writing. And lease contracts requiring payments of $1,000 or more must also be in writing to be enforceable. That's UCC 2-201 sub 1 and UCC 2A 201 sub 1. So sales of goods and leases of goods. All right. And just as a reminder, there are two requirements to meet this statute of frauds requirements in the Uniform Commercial Code. First, the writing has to indicate that the parties intended to form a contract. Second, in addition, the writing has to be signed by the party against whom enforcement is sought, e.g., the defendant. And here is an area where business persons need to take special care, because if this statute of frauds rule applies, then the contract may not be enforced for any amount of goods beyond the quantity stated in the writing, right? So if you revise the order orally, right, then it may in fact become unenforceable, right? But we should definitely note that there is a little bit of a caveat with the statute of frauds stuff, because we know that as between two merchants that the rules might sometimes be a little bit different. So say you have a statute of fraudable, right, contract provision, right, that needs to be in writing in order to be enforceable, right? Suppose that between two merchants, one takes an order and then fulfills that order, and that order should be subject to the statute of frauds, but it was made orally, right? Then the parties will, if that amount was made orally, the merchant can actually send a writing after the fact that actually satisfies the statute of frauds requirement, right? It can basically memorialize, right? And that agreement will be enforceable against the other party even though they haven't signed it, if they don't object within 10 days. And that is UCC 201 sub 2. It only applies to sales transactions, does not apply to lease. There are three basic exceptions to this statute of frauds rule, right? And they are: 1, for specially manufactured goods; 2, for admissions to a contract; and 3, for partial performance. First, let's discuss specially manufactured goods. Specially manufactured goods are those which are made to order, right? Rather than produced for the mass market, they'll be produced for a client. So an oral contract for specially manufactured goods, sale or lease, right, will be enforceable even if it's not in writing, if they were manufactured for a particular buyer, or specially manufactured or obtained for a particular lessee, right? Secondly, the goods aren't suitable for resale because they were so specialized, right? So they can't be sold to others in the ordinary course of the seller's business. Or 3, the seller or lessor has substantially started to manufacture the goods and has made commitments for the manufacture or procurement of the goods. All right. So if those conditions exist, then there may be, despite the lack of a statute of frauds worthy writing, there still may be an enforcement of that contract. That's specially manufactured goods. That's the first category. The next category, an oral contract for sale or lease of goods is enforceable if the party against whom enforcement is sought, meaning the one who has to sign, e.g. the defendant, admits anywhere in the litigation process, pleadings, testimony, or other court proceedings, that a contract for sale or lease was made. Because this is an admission against their interest, it will be regarded as enforceable. So here is a bare bones example of an admission, right? So a farmer agrees to two oral arrangements where he sells soybeans and corn to a agricultural collective. We'll call it Glacial Plains Cooperative, right? So these were four different agreements, two of which concerned soybeans, two of which concerned corn for the farmers' crops to be sold to them and then distributed by the Glacial Plains Cooperative. The farmer made the soybean deliveries, meaning he executed the contracts with regard to the soybean delivery on his side. With regard to the corn, he partially delivered the corn, and then he found a higher bidder, and he sold the rest of the corn, despite the existence of this oral contract, to another buyer. The Glacial Plains Collective had to obtain the corn from elsewhere to fill their orders, and they had to pay a higher price, whereupon they sue Farmer Brown, or in this case, Farmer Lindgren, for breach of contract. Now, this is a contract for sale of goods. In this case, it was greater than $500. It was all of his crops, soybean and corn. And he was, he could have, without this admission rule, escaped liability for this oral contract. However, in his admissions, remember admissions is a type of evidentiary discovery process, right? So in his admissions, he actually admitted that he made the contract. He admitted that he breached the contract, and that was basically the end of the case. Or at the end of the day, that's what determined the case from the pleadings alone. So that is admissions. So the next exception to the statute of frauds rule is partial performance, right? So if there's an oral contract for the sale of leased or goods, and it's, obviously would be subject to the statute of frauds because it meets the $500 threshold for sales and the $1,000 monthly threshold for leases, if there is partial performance by one party, that's an exception to the statute of frauds requirement. So here's an example. So Jamal orally contracts to lease to Opus Enterprises 1,000 chairs at $2 each to be used during a one-day concert. Before delivery, Opus sends Jamal a check for $1,000, which Jamal cashes. Later, when Jamal attempts to deliver the chairs, Opus refuses delivery, claiming the statute of frauds as a defense and demands the return of the $1,000. Under the partial performance rule, Jamal can enforce the oral contract by tender and delivery of 500 chairs for the $1,000 which he accepted. Similarly, if Opus had made no payment but had accepted the delivery of 500 chairs from Jamal, the oral contract would have been enforceable against Opus for the $1,000. Again, same. The lease payment due for the 500 chairs delivered. All right, that's a partial performance exception. And so this brings us to the parole evidence rule, which will be the last topic that we cover in this particular unit. You can certainly free to peruse the rules on international sale and lease contracts, but I'm not going to focus too much on that. Much of it will follow the conventions of international commerce, which are not that much different than the conventions of within the United States commerce, right? So the parole evidence rule, right? First, parole evidence is evidence that is extrinsic to the contract that goes to try to prove what the contract says, right? So we recall that parole evidence or evidence outside of the contract, prior agreements, oral agreements, or contemporaneous agreements that were outside of the actual written contract, that cannot be used as evidence to establish the terms of an integrated agreement. The terms of a fully integrated contract can't be contradicted by this type of extrinsic or parole evidence. But, all right, if the writing contains some of the terms the parties agreed to, but not others, right? The contract is not said to be fully integrated. It's not a fully integrated contract. A fully integrated contract contains all of the terms that the parties agreed to. If they, for some reason, like a Scrivener's error or just for whatever reason, leave out certain terms, this non-fully integrated contract can find a court in a position to permit some evidence of terms which are additional consistent terms, meaning that they have to be consistent in order to be accepted as additional terms. They can explain the terms of the contract, right? Provide terms that are not in the writing, but under no circumstances will a court permit the parole evidence to subvert the actual written terms of the contract. All right, they generally would be the same as the rule under common law in this case. So in addition to the express terms, we've got the possibility in a non-fully integrated contract of dealing with certain types of parole evidence. They fall into three basic types: course of dealing, right? And course of dealing is dealing with the series of communications between the parties that are outside of the contract, right? Usage of trade is the second one, and that's any practice that is common or regularly observed in a vocation or trade or business that might be applicable, right? And then there's also course of performance. That's conduct that occurs under terms of a particular agreement, ongoing conduct. Like say you've got a requirements contract that runs for a year, right? And then there's a breach in month 7, right? And that breach relates to, something that is not clearly set forth in a fully integrated contract, right? You can bring in evidence of how the parties performed, including anything that the parties may have waived or anything that the parties may have, done to sort of evince their intention as far as what the contract is supposed to do for both parties. So that's course of dealing, usage of trade, course of performance, and as a practical matter, courts are going to look to the 4 pieces in a non-integrated contract in this order. It's going to be express terms first. They are primary. Then come course of performance evidence, then course of dealing evidence, and then usage of trade evidence. If you think about it, it makes sense. The express terms of the contract are the closest thing to what these parties intended at the time they made the deal, right? That's number one. The course of performance is how these people have, within this transaction, behaved, right? And then there's course of dealing, which is how these 2 parties have behaved over the life of their relationship. And then lastly, there is usage of trade, which in fact is, doesn't require it to be related to anything that the 2 parties themselves did, but in fact, how does this industry handle this issue? If there is no other better evidence, such as course of dealing or course of performance, or of course the express terms of that contract. And I'll leave us with one additional tidbit before we move on to title and risk of loss in our next chapter. Unconscionability, which you will recall from Business Law 1, a unconscionable contract or an unconscionable contract term is one that creates substantial inequity. It's so unfair and one-sided that it would be unreasonable to enforce it. Very limited circumstances where that would actually be the case, but it is a possibility. UCC 2-302 and 2A-108, there's not most of the numbers match up, but in this case for sales and leases there are 2 different provisions. The court, if they find this breach of equity, can do one of 3 things. 1, refuse to enforce the contract. 2, enforce the remainder of the contract without the unconscionable part, so they can remove the unconscionable provision. Or 3, they can limit the unconscionable provision's application in terms of this particular contract. So that brings us to the end of the formation of sales and lease contracts. Please respond to the prompt below, and then we'll move on to title and risk of loss.